Yes.
2013 criminal division. One complaint against the confirming judgment they had come up. Your lordship had allowed my mention. It was listed last week, but could not reach. Can it be taken up because from 2013 I had not got a single file.
130
130.
included in list Monday. What did you take him out?
2,35,000.
You tell the other side also.
From the other side. That I'll make a mention to.
Pardon to mention, Your Lordship, item 132 of the weekly list, Your Lordship. It may be taken up if.
It will be taken up. Why do you apprehend that it will not be taken up? It will be taken up. Get ready. The moment I get the time, I'll take it up. Don't worry. It is there, let it be there. Huh? And it is appeal.
Yes, Your Lordship. I've already filed the written notes on served the
Which
same.
year appeal?
2018, Your Lordship.
18. Tell the other side so that they will also get ready. Okay.
Yes, Your Lordship.
Okay.
Your Lordship will reach today, Your Lordship.
Today may not be possible, but I'll take it up. I'll take it up. Okay.
Bless Your Lordship.
Note it down so that we'll take it up. Monday. Okay. Any mentioning the BC?
Item 1. And to be mentioned, my lord. Already, my lord, they have agreed.
No. What there is see in the petition who is the counsel for the petitioner?
Earlier, Mr. Kanun Gomal, senior advocate.
See, the problem is the case numbers are written everywhere different. Prayer something, front page something, first paragraph something.
They have not given also GR case number to us, my lord.
See the complete confusion.
Interesting, my lord, in the meantime, already submitted, and they have challenged the FIR. But that I have given also filed the written argument.
That's that boy who was.
They have challenged the FIR, initiation of FIR. In the meantime, charges are already submitted. They have to challenge the cognizance matter or enter criminal proceeding.
But this is the during pandemic, the thing which has happened. Oh, that the young boy, I thought that will pass, but the which proceeding will pass.
They have not.
The numbers are different and all.
They are not filed the GR case number, my lord.
Nothing is filed.
Only PS case number given.
I pass it over, just ask him. Clarify, otherwise I'll dismiss. Then call and tell. We can't take that pressure.
No.
Which case will cost? He'll tell me. Everything is different.
They are not provided me also GR case number.
I gave the dictation.
Even if
Thereafter I saw which case. I don't know which case will come. Yes.
Item
So
2.
casually it is fine.
Item 2 typically permitted to withdraw, my lord. Item 3.
Item 3, my lord, you can be challenging the order of cognizance, my lord. But what happened, my lord, in the meantime, all the co-accused persons already released on bail. All the co-accused persons are already released on bail and case is transferred to the Sessions Court. So far, the other any split up case. I pray that we faster second and priority maintain
But you are absconding, therefore you filed challenging cognizance.
that. After second and priority maintain, that's it. Because other persons are already
Petitioner has challenged the order dated 26/11/2020.
26/11/20.
20
2020.
passed by SDGM Denkanal and GR case number 1377 of 2018, whereby cognizance for offence under section so and so has been taken against the petitioner. Against the petitioner. The petitioner was been absconding in the case. And in the meantime, other accused persons have already appeared and they have been enlarged on bail. Petitioner is not pressing this petition, however, seeks indulgence of this court to pass an order for early disposal of his bail application if he surrenders. On instruction, he says that he would be his client would be surrendering on or before 30th of August 2024 and seek remedial under law. If he moves on a bail application, the same can be considered on the same day. Yes.
Parity amendment.
Parity, obviously parity is there.
1 week more, my lord, because
No. 2000. I'll dismiss it right now.
Extremely,
2000, I am giving indulgence only because the other week got.
extremely sorry, my lord.
One, my lord.
To be mentioned,
See,
matter.
what have you written?
That is exactly now we have recognized that
I have also recognized I have dictated the order, but I have dismissed it.
Sorry, my lord.
Can't do it so casually.
Sorry, extremely sorry, my lord. We'll give a memo to that.
Which
effect.
matter I'll cause?
No, I understand your lord's.
This is so pathetic. I have been struggling to get the case number, everything is.
It is our duty. It is not a court duty. Sorry.
Please don't file
Sorry,
casual
sir.
petitions.
Sorry, my lord.
My lord, one thing, that order of cognizance, my lord, it mentioned that 26.
Correct it. So
Make a
give
note to them.
CR case number, give something. Yes,
26
Oblige me.
11 2022 2020.
26.
26 11 to 2020.
Which item you're talking about?
That item 3, my lord.
3.
My lord. 26 11 2020. That's order, my lord.
No, 26.
20, my lord.
Item 4.
Vigilance matter, my lord.
Sorry, Lordship, my senior is on the way.
Password?
One Passover.
Huh?
One Passover is leave
Yes.
your turn.
Item 5.
Item 5, my lords.
Yes.
Custody is 23/3/2023, my lords.
23/3.
2023.
Okay.
Charge sheet is from
23/3.
23/2023.
23. Okay.
Charge sheet is
Last time, let's see,
23/5/2023.
my lord, this one court, my lord, coordinated marriage, directed the IAC to appear before with the victim, my lord. Has appeared, my lord.
Gotcha. What is this offense?
376(3), my lord. For that,
She never said anything against the petitioner, my lords. Even 164 and see.
See that. Let us see.
my lord.
You should have argued on merits. What to do now? You renew a bail plea after the, what is the stage?
What are the,
Hearing the objection, my lords.
for examination of the charge sheet has already been submitted.
3
Submitted
months.
also, my lord.
3 months. He can't stay more.
Fine.
Huh? The petitioner is agreed by the order dated so and so, whereby the trial court has rejected his bail plea. Meanwhile, the trial is proceeding at the expected pace. Pursuant to the order dated 26/7/2024, passed by the coordinate bench, the informant victim has appeared along with the IAC. Where IAC?
Formula
Formula
documents.
Rampur.
Huh?
Formula Rampur.
On the query from the court, she has a strong objection to the grant of bail to the petitioner. Grant of the petitioner. In that view of the matter, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew his bail plea after the victim is examined in the present case, or after the expiry of 3 months. 3 months if the trial is not proceeded at an expected pace. 3
Much
months.
obliged.
3 months you stay out.
Item 6.
Item 4.
Yes, sir.
Item 4, your lords.
Paso,
Item 4.
4, my lord, that is vigilance matter. Sir. Vigilance matter.
you are asking Paso.
My junior had asked for password because I was coming in.
That's 4.
Four.
Okay. You reverse way.
Leave
This reverse is not allowed. That's right, but reverse is not allowed.
One password was short for your lordship.
Okay, it's all right. Today I am giving, but don't ask me to go in reverse way.
But I wish,
It was asked for one password, your lordship allowed.
Yes, yes.
and I wish, my lords, in the item number 4, my lords, either Beach or Sangram, something like that. I was expecting that to ascertain that's a vigilance matter, not that's missing. It's all my lords. Let my learned friend as places case, not I've not brought the files, but I will answer on the next date.
No. Bail what parted?
No, it is bail. It is not bail. It is criminal division.
Acha, revision.
Division, my lord, I have
Against?
again the rejection of discharge.
Then it has to be heard. You don't have the file?
You
Let him
lordship,
come.
one thing you lordship may do that. You lordship may adjourn it to next week. 16, my lord, is posted for framing of charge as last time. You lordship may say that I will ask for adjourn.
You can manage, sir.
No, that
matter
is
is
last.
pending
No,
here.
it can be managed.
You are able to manage in the
No,
High
no,
Court.
your- the order, specific order is last chance. No time will be granted. You lordship may say, what is the harm in it?
ठीक है,
I am not praying for stay.
The-
I am saying.
That is indirect stay. Thereafter you
No,
will ask for it.
No, my lord. Next week it will be posted for fresh admission.
Right down. on the request of Mr. Sangram Das, led counsel for the vigilance, release the matter next week. Led counsel for the petitioner submits that before the trial court, the matter is fixed on
16th,
16th.
16th, 8 to 30.
Therefore, he would be seeking an adjournment there for 40 days. It's made clear that the petitioner may seek an adjournment. Adjournment owing to the fact that the matter is submitted before the court, but this arrangement is only for next date of hearing.
That may be allowed by the trial.
And my private my lords,
That may be allowed by the trial.
each may be indicated next so that to ascertain.
The name of Mr. Das should be indicated.
That adjournment may be allowed by
Yes,
the
I have written. Yes.
may be allowed by the trial.
Maybe allowed. I have checked.
Yes.
Yes.
Reply it was your urgent certified copy or it may be transmitted through net, either of the two.
Today will immediately.
Yes, ma'am. Or in course of the day.
Six.
My item is second one, my lord.
Sorry. First one you are there? Yes. Yes.
Offense under section 457.
First one, let him argue. Yes. Both are co-accused.
That's
With the
fine.
same
I am
FIR.
for three, he is for.
Hmm.
FIR,
Charge sheet?
Charge sheet or something. FIR of 1/11/2020.
It has been submitted, my lord,
Ah,
keeping
that's-
investigation open.
Charge sheet on 29/2/2024. Same allegation.
Custody?
Custody 3/11/2023.
22.
My lord, charge sheet has been submitted, my lord, keeping investigation open, my lord, because including these two petitioners, Padmanabha Deori and others, and Tapan Kumar Pradhan, they all were apprehended by the villagers. They have gherao to them, and all the 6 numbers along with the motorcycles, they were detained there, and the police came to there and arrested.
It's a case of 307.
Yes, my lord, 307 and also, my lord, my lord, 307 and 395 and 25 1B, my lord.
Show me the injuries. What are the injuries?
Injury, no external injury.
My
What
lord,
the allegation? Just show me.
my lord.
Allegation against the only.
What about the other accused persons?
Out of 8 persons, 6% has been caught out by the village persons. 2% has
No,
been.
2 of you are there.
Man, I am for the 6%, I am for the 3%, he is for 3%.
All the 6 persons. Okay.
All the 3%.
What are the allegations?
Man,
What are the allegations?
allegation against the seizure of 45,000, one gold chain, gold. Allegation against the 4 petition. 70.
Deadly weapon. What are the weapons recovered?
No, weapons recover.
Yes, and ornaments.
Cash is only 45,000. Gold mali, what a earring.
Other two
Pistol is there.
Two mobile phones.
2 mobile phones.
Ibani Pradhan and People Panga, Incubera, Guduri Pudi have fled away from their spot, and the rest of money has not been recovered from them.
Oh, why for you kept 173.8 open?
Because the rest of persons, till yet they are not.
There are 6, na?
Yes, madam. No, others are there, other 3 are there, 9 numbers.
Now total out 8%.
Total
8%,
8%.
2%.
Two of them are not apprehended. You are in custody since
2023.
And my lord, the another accused who has been appeared, Tapan Kumar Pradhan, having one criminal antecedent in same nature of allegation, my lord.
Sir, your bail application was rejected on 30th of November. Thereafter, the charge sheet is filed. You have to go to the first court.
Yes, my lord.
Right. The petitioner raised the bail plea before the court below. At the time of when the investigation was going on. By the order dated 30th November 2023, the bail plea of the petitioners have been rejected. Subsequent thereto, on 29th, should approach the court of first instance by renewing the bail plea. With this of liberty, the petition is disposed of.
My lord, second bail application after charge sheet filed the bail application.
After charge sheet, okay. You go after charge sheet.
Tapan Kumar Pradhan.
Yes, my lord. Second bail application.
When you have bail application. was
Bail
rejected,
application filed on 12/1/24, my lord.
I adjourn it for 2 weeks because
Yes.
if I
Yes.
grant bail, they'll get the penalty.
Yes,
You,
yes,
you
yes,
go,
yes.
you first apply there. You first apply, I am.
About 10 months custom.
It's all right, but see, you, 8 of you have gone with pistol and all, enter into somebody's house, snatch
No.
everything, beaten them up,
No.
and so many things you have stolen. In the daytime, what is this?
Thrown to a.
There is no pistol,
And
my lord.
the villagers,
Seizure of no
this
pistol.
seizure is something different. And you, the villagers have got you there,
The 5 ବର୍ଷର ପିଲାକୁ ଘର ଭିତରେ
and a small baby was beaten up.
No injury on that.
Injury is all right, but see, the allegations are so serious. So therefore, you should be there. Get to bail, but after some time. Wait for after 2 weeks, I'll give you. After 2 weeks, you come. I am adjourning his application because he came after the
After
charge is filed. I'll consider it. If I'll allow or do something, it will have an impact on you. So therefore, I'm adjourning for 2 weeks. You try there. If you don't get, then you'll get parity. I'll allow.
That like direction may be given.
Lord, in date, my lord, can you fix?
Yes.
Can you any date?
Date after 2 weeks, we'll give. Next.
7 on behalf of Mr. Nanda, 1 week after I pray for my.
1 week, huh? Adjourn.
1 week.
Yes. Adjourn. Yes.
Yeah, my lord, the petitioner is languishing in the jail custody 7/10/2000, 10/2023.
23, okay.
It is suicidal hanging and the death is, my lord, by bolting the door.
Charge is filed.
Charge sheet 302, my lord. Before submission of charge sheet, he has moved before the trial court.
Let us
Your
see.
lordship.
Okay, charge sheet, my lord, 302. Your lordship, there is
Angry-
injury.
No, my lord, no injury, my lord. All the witnesses have
Before
said,
submission
and the
of charge sheet, he has
co-accused person
moved.
Released on bail.
What are you showing?
I am showing the co-accused person. Bail.
They are the in-laws, my lord, old
No.
parents-in-law, my lord.
Can you please allow,
Petitioner.
can you please allow him to complete the
yes.
sentence? I have been telling you every time. If somebody started a sentence, allow him to at least complete that sentence. Thereafter, you start your sentence.
Your
What is this shouting like this? Don't convert the High Court to a Machli Bazaar like this. He is saying something. Please hear what he is saying. He is saying co-accused persons have already been granted bail. Okay, they are mother-in-law, father-in-law, whatever. And let us see what is the case is about.
yes. Here, my lord, while the
Yes.
Lord and the coordinate bench had granted bail, clearly observed that allegation is omnibus in nature and the, my lord, deceased.
Show me what are the allegations against you being the husband.
I am the that
What is the cause of death?
cause of death, my lord. That is a case of suicidal hanging, bolting the door. The, my lord, deceased committed
From inside.
Yes, my lord, all
Show
the, yes,
Show me that.
yes, my lord, all the.
Show me which, read it that part.
Yes, my lord, I am reading.
See, hang bolting the
Yes.
door from inside.
ଶ୍ରୀମତୀ ଟୁନି ବେହେରା, my lord, relevant ଯେହେତୁ ଆମେ ରାଜକିଶୋର ପଣ୍ଡାଙ୍କର ପଡୋଶୀ ଅଟୁ, ତେଣୁ ପ୍ରାୟ ସମୟରେ ଆମେ ରାଜକିଶୋର ପଣ୍ଡାଙ୍କ ଘରକୁ ଯାଉ। ମୁଁ ରାଜକିଶୋର ପଣ୍ଡା ଓ ତାଙ୍କ ପରିବାର ସମସ୍ତଙ୍କୁ ଭଲ ଭାବରେ ଜାଣେ। ସନ୍ଧ୍ୟାବେଳେ ଆମେ ତାଙ୍କ ଘରେ ସମୟରେ
06 of IPC 06 of IPC with this husband and mother-in-law, and finally the father has been already discharged, my lord, from the final charge. My lord, the marriage was solemnized just before 4 years back, my lord.
That is why
And now
304B.
they having the 2 years child, my lord. My lord, according to the charge sheet, my lord, postmortem is there, maybe due to anesthesia and strangulation, and it is fact
No,
that
it's not strangulation. It says that the postmortem report does not reveal any external injury
yes,
on the body of the deceased so as to support the allegation of physical cruelty. That's the finding of the coordinate bench while granting bail to one of the accused.
both.
Both the accused.
my lord, come back
How to
with
get out of it?
generous condition, my lord.
Place this thing on record, put it Tuesday.
Yes,
Put it Tuesday. Yes. Place this thing on.
file it, my lord, by
Tuesday. Okay.
I'll file a memo.
Okay. Next.
For next week, we don't have to receive the deposition copies.
Next week?
Next week or 1 week?
Urgent.
Can my lord, I pray for 2 weeks after my.
Why you are today only in the mood of getting urgent?
No, my
Something like
lord. The earlier case was one, Mr. Nanda asked me to take adjournment.
that? Urgent.
Public.
Okay. Why the bail application? Why are you seeking adjournment? You do it here or there, whatever.
I will obtain the status of the case, my lord.
Okay.
My lord.
11.
Yes, my lord, I'm filing my Vakratna. Prison petition is there also, my lord.
What is the case? Prison petition, huh?
Yes, my lord.
If offense, will you argue today or?
Lordship, if the matter will taken up some other day, then I'll be obliged, my lord.
Okay. Learned counsel for the petitioner has entered appearance.
Can I? An application before the law and sessions. After filing of charge.
So simultaneously, you moved to trial.
My lord, today I am appearing, my lord.
Oh, the jail petition. You might be. So you challenge this order also, because there is a see this petition was. I'll tell you, this petition was filed when
This order was on 7/2/24.
7/2/24.
Charge sheet was filed on 17/2/24. So in the meantime, he has.
June 24, it is rejected.
And
24
then
June.
subsequently, he has filed another case before the court below and it was rejected. So he may withdraw that petition and challenge the same.
Yeah.
My lord, I don't know. I have to go through the interview for
But I
once
tell you,
at least.
he's a jail petition.
Yes, ma'am.
And if you ask him, then he will contact the jail authority and it will, what is the offense?
And on the basis of that,
420, 468 and all.
420, 467, 468, 379.
This was also a bail jail petition. This one also. We'll hear it because jail. The person is in jail. He is not able to communicate with anyone.
Yes, my
He's
lord.
sending papers, and applications are moved.
What my lord, technically is that one which was rejected, he was filed this bail application. And subsequently.
I understand it.
Subsequently, he's filed another bail application before the court below when this petition is pending.
Why don't you?
If your lordship, merit review jodi kahibi, my lord, it's a
See, technical problem is the
Yes,
earlier order you are challenging.
I can understand, my lord,
Subsequent
that
thereto, there is
difficulty.
another order.
That may make some kind of chaos, my lord. So that is why 1 week time may kindly be granted, my
Okay.
lord.
You just this also you bring out on record.
Yes, my lord.
So that
I'll
you
go
see
through it, my
If he is entitled for bail, we'll grant bail even if because it's a bail.
Yes, ma'am.
WhatsApp number.
In jail petition, why should you have lot of technicality? If he is entitled to bail, entitled to bail.
No, if on merit, your lordship will have, if he is entitled, your lordship.
You place that order is also on the record. Yes. Urgent on the request.
Obliged, ma'am.
Item 12.
Yes.
Well, my lord, charge sheet was submitted under section 3763, 3762, and 6 postpone.
3.
3 is there.
The notice.
My lord, notice was sent, but yesterday night I have taken instruction.
Yes.
That notice was not appear for an Indian.
Appearing for
And the petition, my lord.
what about
So
the notice?
unfortunate, my lord, before bail application could be disposed of, he was acquitted, he has been acquitted. And my bail application is pending.
That's the plight. What to do?
But I am getting nothing, my lord.
You got everything now. You acquitted. Then counsel for the petition submits that during the pendency of the present bail application, the petitioner has already been acquitted by the trial court, hence nothing survives. This is the whole difficulty. We are not able to dispose of bail application. People are languishing in the jail, they are facing trial and getting also acquitted.
It is a case under 490 day, no 376 is made out. What is it?
But therefore, you people please don't ask for adjournment if the matters are legal.
No, we have not adjourned, my lord.
And
It
bail
was-
matters, I'm telling you for the benefit. Don't ask for adjournment. If the bail application is there, this way or that way, it has to be disposed of. You ask for adjournment and all, and this will be the result.
Out of 10 cases pending, my lord, 4 has been in transport.
Yes.
Obliged, 13.
May I please, your lordship?
Yes, madam.
Your Lordship, charges under section 376 AB, 363 and 6 of POCSO.
Hmm.
Here,
Custody since
in custody since
22/6.
22/6/23, 2023, Your Lordship.
yes. What are the 164 so the boy is about boy
15 years. 15 years, Your Lordship.
Is the date of birth is 25/3/2000.
boy is 15 years. The girl is
12 years.
7 months. 11 years, 7 months on the date of birth.
I'll grant bail.
My lord, what happened, my lord?
No, whatever may happen.
No, that
15-year-old boy
No,
can't keep.
376 AB was there. The lordship issued notice. Notice was served to the informant on that may be recordable. But that is notice was served to the informant on 27/3/2024. On the date of rejection order, my lord, on 8/1/2024, 14 witnesses were examined out of 21. Out of that 14 examination, my lord, victim was examined in PW2.
Yeah, also supported the
My
procedure.
lord, that deposition copy is not with me.
Also, everything is over now. Why should you be there? Everything is there is no question of threatening. Also, this boy is 15 years.
And my lord, the medical exams report is that there is signed.
Whatever if you convict, then it's something different. He is in custody since 26/6/2023.
22/6. 22/6, Your Lordship.
And the sign is there. No,
all right,
was
but-
examined.
Your Lordship, it was a consensual, Your Lordship. It was a mutual relationship between both the petitioner and the
They
victim.
are very young.
And my lord, that the boy's medical examination report that he is also capable for.
Right. Right now, petitioner is accused and so on. Although the allegation against the petitioner is for a serious in nature, the victim girl who was what is the age?
11 years, 7 months.
11 years, 7 months at the time of incident. She has made there was a relationship.
Yes, Your Lordship.
Before she stated that she was supposed to be taken, madam, reading that. But though she was examined, my lord, so it deposition copy will be better if the lordship will.
164, what does it say? They must be in the relationship.
କହିଛି ଯେ ମତେ ମାନେ ରିଲିଭାନ୍ସ ଯଦି ମକ ରେପ୍ରେଜେଣ୍ଟେସନ ମତେ ଖରାପ କାମ କଲା ମୁଁ ସାଙ୍ଗମାନଙ୍କ ସହିତ ଖେଳୁଥିଲି ସେ ମତେ ଡାକି ମୋ ଉପରେ ବସିଗଲା.
Only you have to take instruction.
Adjourn.
Okay.
15.
May I please, Your Lordship? It's a case under section 302 of IPC, custody since 19/8/23.
19/8/23.
Yes.
Okay.
The deceased is the son and petitioner is the father, my lord.
Father killed the son.
Yes.
Yes.
Now, my lord, what happened in this case? This is just drunkard person, my lord. He used to take liquor, and after coming to the house, he used to beat his children, his wife, the father, the mother, everything.
Okay.
And once, my lord, he has broken the knee of the father. On the date of incident, in an intoxication manner, he came and assaulted all of the family members, and also assaulted on the injured knee of the father.
Okay.
For which, without out of anger, my lord, he picked up a spade nearby the bed, given a single blow. This is the case.
Single blow.
Yes. And the
Yes.
4 eyewitnesses, those who are present on the spot and stated in this manner.
Let counsel for the petitioner submit that petitioner is the father of the deceased. It is the case of the petitioner that the deceased was a drunkard, used to come home and beat the entire family member, and he had already injured the petitioner by breaking the knee.
Yes.
By breaking the knee on the fateful day, and at the same thing he repeated fateful day, victim has repeated the same thing. He came home heavily drunk and attacked all the family members, and also beaten up the father in the injured leg. Out of and the fit of rage, the petitioner picked up what is it?
Spade.
A spade, and gave a blow in the head of the deceased, to which the deceased succumbed. This is the case of a single blow turned to be fatal, and the conduct of the was unbearable. Therefore, out of in the fit of rage, the petitioner, who is the father of the deceased, has given a single blow, as a result of which the victim has expired. Since the petitioner is already in custody since 19/8/2023, and the learned counsel for the petitioner further submit that the eyewitnesses to the incident have been examined in the court, and those who have not supported the
1, 2, 3, 4. PW 1, 2, 3.
Examined the court as PW 1, 2, and 3.
4.
And 4. Those who have not supported the prosecution case. In view of thereof, the petitioner is entitled to bail, and yes. Granted. Yes.
16.
Yes.
16 Lordship has been convicted for 3 years.
Convicted. During the pendency of the present bail application, the petitioner has already been convicted. In view thereof, the present petition doesn't survive. Convicted by order dated. We have.
Yes. Para 12 Lords.
Where? Show me. Tell me the date. The entire history, geography, everything is written except the date, which is necessary.
Yes, sir.
Right now.
Or is that I will communicate.
Convicted, nothing survives in the matter. Dismissed. Yes.
May I please?
Yes.
Petitioner is in custody 16/5/23.
16/5/23.
5/23.
Okay.
There is no eyewitness to the occurrence, my lord.
Offense?
302.
Okay.
120B, 302, 394, 201/34 of the IPC.
Hmm.
Read with 25, 1B, 27.
What are the allegations?
Allegation co-accused statement. I have been entangled in this case, my lord. That co-accused Prakash Khattu assessed that the petitioner keep watching the movement of the deceased. That is the allegation, sole allegation. Co-accused statement.
You have not participated in
no.
He was monitoring. He was sending all those persons. And
he
this
passed
thing,
on
they have
the-
also, all the 3 persons, they have confessed that this thing was monitoring by the.
No, except confessional statement, what else you have?
That is the things only. The
Confession statement of co-accused, how can you read against him?
be there.
Do you have any other evidence?
Other evidence is not.
There is nothing. If you have any connecting material, you tell me. If you don't have any material, I have it.
No, that is not.
Nothing.
That is not.
Petitioner is accused himself. The allegation against the FI. Okay. Land counsel it appears from the prosecution story that the petitioner has been arraigned as an accused on the basis of the confessional statement of the principal accused, 3 principal accused.
Yes.
3 principal accused. It is alleged against the petitioner that he has been tracking the movement of the deceased.
He was also with them.
And tracking the movement of the deceased, and has been informing the same to the principal accused who have caused the assault, as a result of which the deceased succumbed. passed on the information to the principal accused, those who have caused the crime, except land counsel for the state submits that except the confessional statement, there is no other evidence available on record. The petitioner is in custody since 16/5/2005, 16/5/2023, 23. Just now you have gone, not even.
No, 23.
Okay.
More than a year he is in
1
custody.
year. Granted. Okay.
Okay.
Yes. 18. And it is always better that you should appear for petitioner only. Don't oppose. You are unnecessary shouting. Because you know that you don't have a case.
Charge sheet.
When somebody if you have a case, you need not shout. Slowly you tell. The court will understand. Give the relief. Yes.
May I please your lordship? I appear on behalf of Mr. Patra. The case has become infructuous as the matter has already been resolved by the mediation on behalf on basis of
the second item is on concern, my lord.
It is a bail.
Yes, it's a bail matter that this case, my lord, that the honorable this court granted interim bail for a period of 2 months, my lord, and sent back to the mediation center. That the photo, my lord. That
Then they have settled the dispute.
Yes, yes.
Then this interim order has to be made absolute. Otherwise, how it is
in meantime, the development of this case, my lord, that the complainant had 320 application before the magistrate. This is the order, my lord. And the
they
court-
compounded.
Yes, yes.
It's already passed the order that they don't which they did not to proceed with the justice.
And they already
This court had granted interim bail to the petitioners. Both the matters?
Yes, yes, my lord. That the first
both the
proceeding.
matters. Interim bail to the petitioners. Interim bail to the petitioners. Petitioners. And delegate the petitioner and the informant to the mediation center. The mediation came out to be successful, and thereafter they moved the application before the trial court for compounding of the offence. And the offence has already been compounded by the order dated 22/7/2024. Hence, nothing survives in the matter and disposed of.
So we're filing the memo.
Dispose of memo is not required. But dispose of, yes. 19.
Petitioner is in custody, my lord. 19 January 24. For
19 January
24.
Yes.
For alleged offense 376/511 along with other offenses, my lord. The victim lodged an affair. He is 21 years age. The petitioner is 26.
164 sorry.
मिलर 2018 मामू बाहागर बापी सुबुद्दीन सह चिन्ह है 2020 मसीह मत प्रपोज करथिला मोर संपर्क बोली से कहला सब बुझीबा मोर इच्छा नथिला किंतु से बाध्य कला
nude photographs viral?
No, not by
14/2. 24 years.
Because the FIR was registered under 302 IPC Millers.
Yes.
302, 304B, 498A, 34 IPC.
The charge sheet?
Charge sheet has now been submitted.
306.
Yes. Copy of the charge sheet, Millers, along with my IA.
You are the husband?
Yes. 925.
Death by hanging, huh?
Page 13, your lordship may see of the charge sheet.
Yes. What are the allegations?
He has written, page 12, that during course of investigation, examined complainant and other witnesses recorded their statements, sent requisition to scientific officer and to sub-collector to deputy and executive magistrate.
Marriage.
Says all received postmortem report who opined that the opinion reserved pending chemical analysis.
Where are you reading?
Page 12, my lords.
12 is the order, huh?
Brief facts of the case of the IA. IA. Charge sheet tak place. IA 925.
As a 925, okay.
Right.
Now I got it. Yes. Yes.
Page 12 last part, dekhuntu, 5 lines from the bottom.
Yes.
received CEO report from the SFSL Rasulgarh where barbiturates, benzodiazepine group of drugs, alkaloidal, insecticidal, herbicidal, rodenticidal, and oleander glucosidal poison could not be detected from the viscera of the deceased. Received supervision note in which he opined that it's a true case under 498A 306 by 34 and 4 of the DP Act against the accused husband.
Poison not found.
No, no poison was found. 306 max punishment to 10 years. Triable by a.
You filed a charge sheet under 306.
That's it.
Why-
Copy not with him, Lord.
Copy is there in the IA, sir.
IA.
I get a 9.
Read it Tuesday. See, there is nothing.
Yes.
See, there is, the chemical analysis report
Yes.
says that no poison.
But it has been rejected by trial court 29 to 20.
That's right, but there is no poison. Why should one necessary?
Lord.
He is entitled for bail. If you don't have the copy, take the copy.
Let me serve one charge sheet.
Give the copy to Tuesday.
Lord.
Tuesday at the top. Huh?
Unfortunate.
You have you supplied the copy?
Yes, my lord. I have got a receipt showing copy.
Sometime they miss it.
It is not sometime, my lord. These
No, no,
are-
no. Copy diyantu ni khali receipt ta diyantu.
These are means in which cases are adjourned and matters are delayed.
What to do?
That's what happens.
And Tuesday, huh? Tuesday. Yes. Something like that. 40. Revision.
Well, so what's up the facts were down? Initially, it was in this revision, challenge was made to the order of cognizance. Your Lordship will see the input order, it is a composite order. In this, 198.
198,
my lord, page 198 is the order, my lord, order of cognizance.
Yes.
And this was challenged, my lord.
Yes.
Your Lordship sees.
There are how many accused? There are
Several. There are several accused, my lord. I am only in for the one of the accused, my lord.
25 people.
I am at serial number 13, my lord. Jagdish Mishra. Has your Lordship got?
Yes, I got it.
Page 200.
Then your Lordship straight away come to page 200.
18.
200.
18 also the
Yes. 200.
so, page 200 is the beginning of the order.
Yes.
Lord, your Lordship come this order. 202.
201 देखिए.
नहीं.
201. ठीक है. अच्छी protection. Interim protection.
201 will order there.
Yes, sir.
As further report. Third paragraph, my lord.
I am there.
As your Lordship got it.
So far as the accused persons, namely Madan Mohan Vishwal, so and so concerned. So far as the accused, namely
Subpara 3, my lord.
Yes.
As further
As
reported
further
by the
report of-
IO, the accused persons named is Ranjan Mahanti, Sri Subhash Chandra Parekh, Sri Jagdish Mishra, Champak Gupta. I am Jagdish Mishra, my lord. Sri Haricharan Gupta are under interim protection granted by the Honorable High Court. My lord, then 202, my lord. Peruse the FIR, charge sheet, and all other cognizance is taken, my lord. Then, in view of the prayer made by the IO, the envy against the absconding accused persons, namely Purnachandra Patra.
You are absconding.
They were absconding, they were not under protection.
Now, what about you? You were.
Against me, nothing, because I was under interim protection. That is what was written, my lord.
Yes.
Your Lordship is-
Yes, I got that. You were interim protection. Yes.
Interim protection.
Yes.
Then, my lord, after the cognizance, my lord, I was in interim protection before the cognizance, my lord.
Now what happened?
Now, my lord, I am again in interim protection by order dated 5/2/2016, my lord, because on medical ground, my lord.
Okay.
So,
Finally, on 10th March.
now, my lord, at this stage, I am given to understand that near around 50 persons has been already examined.
So there is no question of interfering in the cognizance order. What do you want?
Cognizance. But your lordship, can I draw your lordship's attention to 5/2/2000? 10/3/2016, Miss case number 66 of 2016.
66.
16, my lord. 66 of 2016. Order is 10th March 2016.
Okay.
Your lordship, you see, my lord, my health condition is accepted by the other side that I will put.
Yes.
My lord,
Discharge summary and all.
Yes.
Yes.
Mr. S.K. Padhi, Land Senior Counsel, appearing for the Vigilance Department on instruction.
Where are you reading?
Madam, paragraph 3.
Paragraph page, my lord, order
10/3,
number 32.
2016.
No, you are referring to order passed by this court.
Yes,
Yes.
order number 32.
You referred to IA 66, therefore I am correct.
Yes. 32 dated 10th of March 2020.
10th of March.
2016.
2016 order.
Yes,
Again.
my lord. Third paragraph. My lord.
2016. Okay. Yes. Third paragraph. Yes.
Second paragraph, let me begin. Lord. The petitioner in this Miss case application sought for interim protection during pendency of the criminal division in as much as he is suffering from cardiac problem and has undergone surgery and his regular medical checkup is required. Mr. S.K. Padhi, Land Senior Counsel appearing for the Vigilance Department on instruction submits that the petitioner's ailment as per the medical report furnished by the petitioners BST. It appears that the earlier prayer for interim, but now the petition needs protection on the ground of his suffering cardiac problem as he has undergone cardiac surgery and other things, and that were granted.
What exactly you want? I am not able to.
We want to participate in the trial. 81-year-old man.
What do you want then?
We want a protection.
You are already under protection.
That protection to continue till the trial is over. That is
What is the great thing about it? Why you get that?
That is all, your lordship.
Who is appearing?
Milord, I am appearing for state vigilance.
They are here. He says he is already under protection. The protection should continue. He is 80-year-old man. He will participate. There are many modes to participate.
Milord, what is the danger? Has he given any instance of any danger to him? Therefore, he wants protection. Milord, he is a government. He was a government employee, retired. So he is even in this trial.
You are basically asking for 205 in true sense.
Grateful.
He is asking for two exemption in true sense.
Till date, no charge is framed against him. He is Jagdish Mishra. Your lordship remember.
Has not yet been framed.
No,
segregated.
Segregated. No charge. 11
trial has
years,
already
no
been
charge.
completed.
Yes. So he is Jagdish Mishra, who knowing fully well that he had no valid license to operate the lease, executed a power of attorney in addition to B.K. Mahanti. Your lordship were hearing that Deepak Gupta case.
I need not go into, sir, I need not go into merit. The fact remains that passed. Somehow it didn't appear. It got splitted. The trial is splitted. Now he wants a extension of that order. He is 80-year-old man. Let him go and appear before the court and move application at 205 and that will be considered on its own merit.
Let him go there and file application.
And owing to his age, it should be allowed. What is the because the court has already protected, not that court has not protected.
They are quite fit due to this vitamin M.
I am not interfering in the cognizance order at this stage. That's very
He is
clear.
now adding that here in this case. It is not there.
Okay. I'll pass the order.
Lordship.
Will I pass on this medical certificate?
Latest medical certificates, my lord, is unwell.
I think you should move these things before the 205. I'm not deciding your 205.
The man is suffering. So therefore,
So I will record it. He is suffering, whatever suffering you write down and give. It must be A big man must be big disease.
No,
So you,
no,
that
no,
may be
no,
something.
the age is- no, 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 I don't.
At 63, disease doesn't come with a name. He's 75. So because
So therefore you give the names of the disease which you
we
suffer.
will give that in a
I
slip.
record that and I'll extend the interim
I'm
order.
grateful.
Go and appear before that court.
Correct.
Move appropriate application and
Yes,
205.
yes,
Owing to
Yes.
your age and.
Say that, he will consider all.
May
You
refer to
write
that
it.
2008 Supreme Court, where it says that at the first instance, if summons should be issued and bail should be granted. It is the only.
I think the trial court will take care of all these things.
That is the-
I'll record that and
I'm
I
grateful.
relegate you to the. Yes.
Yes.
I just give me in writing what are the
I'm
diseases.
grateful.
And sir name also. Right. Okay. Yes. 22. Man. Yes.
I have filed for quashing of the FIR, my lord. The petitioner, my lord.
Yes.
FIR has been lost under section 467, 468, 471, 420, and 34. Again, two persons, one Tushar Praharaj and this petition.
Charge sheet filed.
Charge sheet already filed. My lord.
Yes.
Charge sheet already filed. So far as the present petitioner is the entire allegation against the Tushar Praharaj, the father of the petitioner.
Yes.
The allegation against the present petitioner is only that he is
Your
the
Sai Sri Silpa Praharaj.
my lord. He is a +3 science student now continuing his study at Kotak, my lord,
20 years.
Safety College.
Yes.
No allegation never against the present petition, except that he is the signatory being the one of the shareholder of the property.
Cognizance has been taken.
Cognizance for us has been taken, my lord.
Yes.
No allegation is made. FIR, I'm reading the FIR.
No, show me the charge sheet now.
They are not filed. Charge sheet not filed, I have not received also yet.
FIR is very threshold. Thereafter, after investigation, what has come against you?
So let me allow some time. I'll get it from Sambal.
That has to be seen. If nothing has come against you, then I'll quash it.
My
Let us see. Has anything came against?
They have not given any copy.
You just see the charge sheet. FIR.
I've already asked him to get a copy.
You file the charge sheet. Let counsel for the petitioner seeks 1 week time to file the copy of charge sheet.
Also FIR and charge sheet.
FIR filed.
FIR filed.
FIR has been filed.
483.
And within 1 week, least after 2 weeks. Yes.
23. My please, my lord. 23 next week comes. I have removed the defect. I will remove the defect.
Defects?
Serial number 19. Some defects.
19. What is the defect? 19. Oh, the minor defect. Forget it. If you have a case, argue. You are not prepared, it seems.
Yeah, another.
Are you prepared or not?
No, sir. So
Then
yeah.
I'll adjourn it. Forget about you. Let counsel for the that he is not prepared today to argue the matter. List the matter.
The matter comes up 20.
Don't decide the date. We will
Sir.
34.
My lord, item 24, on behalf of Vrindavan Rout, permitted to withdraw with the liberty to file a better application. I'm filing a memo on this.
Then counsel seeks to withdraw the petition to resort to the remedy available with this.
25.
25, my lord, challenging the order of cognizance on the ground of settlement, matrimonial dispute. What happened? The wife in the meantime married somewhere else. So it is it's little difficult to.
Notice was not issued.
No, my lord, notice not issued.
I'll issue notice if the settlement.
My lord.
Have you implemented?
They have
My lord, my lord.
correct address, my lord. Now
This is the address. This.
Let the notice be issued in your father's address. List. It would be difficult.
No. Prachi Tripathi.
My lord.
Aravinda Ponda,
My lord,
village Jayanti Nagar.
my lord,
This address is okay.
my lord,
Issue notice to opposite party.
obliged.
Returnable within 1 week. Do it.
My lord,
Boot a week chhadik lagayge. Take the notice and serve.
obliged.
My petitioner is also given the opposite party number 2, independent from the independent from the regular process. You send a copy to registered post.
Extra copy.
Extra
My
copy.
What extra copy?
How much is it?
26.
Because see, if he has already married somewhere else, he will not come. That's for sure.
No, our father will bring up.
Oh, you bring the father then.
Yes, yes.
Yes.
Lord, so item 26, withdrawal filed.
Who are you?
I am from respondent number 2 and
It is his
I am the
If
petitioner.
it is his petition,
okay, but already 2-3 occasions.
maybe, but his
But
petition
then
is.
it should be, the petition should be dismissed as withdrawal, my lord.
Ah,
Because otherwise every time, earlier
That is
to that,
what-
they have also filed a withdrawal.
Meaning same.
Right on. Legal counsel for the petitioner seeks to withdraw the petition, dismiss as withdraw.
So my
We
name,
must
my
take-
name be recorded,
Right.
A.K. Mahapatra for the respondent number
Yes,
2 and
yes, taking up for it and opposes the same. Opposes the same. Dismiss and as a withdraw. Yes.
May I please your lordships? Let's, the 1cc case was initiated by Lords at Cuttack.
Yes.
Now that is for 420. And another case was initiated for theft at Jagatsinghpur. Plus the complainant had its mobile phone stolen at Jagatsinghpur secure service. I am a public sector company. Now I have no affiliation whatsoever with Biscuit Security. He has added me as complainant, as an accused before the 1cc case, which is before the London Magistrate at Cuttack. The initial statement as well as the complaint.
Informant is this.
Informant is the
Niyati Saha.
Dr. Bimal Chandra Rath.
Biscuit.
Dr. Bimal Chandra Rath is the informant.
Okay.
So,
What are the allegations against you?
The allegation against me is the allegation.
Come to the complaint.
The allegation is against one Biscuit Secure Service. Your lordships may kindly see page 14, the initial statement.
Yes.
May please. And the complainant of this case have filed this case against accused person's Biscuit Secure Service. I had purchased one iPhone 6 Plus model mobile phone and get it insured with the accused insurance company named Biscuit Secure Service on 17/4/2000.
I insured insured with the accused insurance company.
Which is Biscuit Secure Service. So the insurer is Biscuit Secure Service.
Okay.
I am not the insurer. Now what he has done, my lords,
read it.
I lodged FIR on Withdrawal PS on 18/4/2016. The documents after complying the claim procedure to the accused company.
This Biscuit Secure Service must be selling the mobile.
No, the Biscuits, so the mobile he had purchased from one shop. So Biscuit Secure Service was providing insurance to the extent that if it is stolen, then they will be reimbursing it. So I am having no affiliation with them. I am a public sector insurance company, New India. And this particular complainant,
this Biscuit Secure Service is affiliated to you?
Not affiliated to me. That is not affiliated. That's what I also humbly submit before your lordships, that for cases of this nature, when a 420 case is made out against an insurance company, so he has the prima facie materials has to be placed regarding the policy.
Let us come to the complaint.
My lords.
Complaint.
Lordships, kindly see page 15, the complaint.
Yes, I'm there. 88.
So
you are accused number 3 and 4.
3 and 4.
Yes.
Let's kindly see page 16, the last paragraph. That on 25/4/2016, your organization Biscuit Secure Service issued. The organization Biscuit Secure Service has received the claim settlement notice and the intimation number, so and so, and the further asked for certain documents which was required for settlement of claim. So the entire correspondence is with Biscuit Secure Service.
Why they made you an accused?
I was failing to understand, my lords, and even
I'll issue notice and stay.
My lords.
Yes.
Deeply.
Issue notice. The petitioner, petitioner number 1 is the chief manager.
Chief manager and managing director.
You are a public
sector insurance
Insurance.
under the central government.
The petitioner number 1 is the chief manager of New India Assurance Company, which is a public sector insurance company. And petitioner number 2 is the CEO, managing director and CEO of the said insurance company. The opposite parties, number 1,
My lords.
number 1
My
had
lord.
filed a complaint at the opposite party number 2 and 3.
My lords.
2 and 3. Inter alia making allegation that they have purchased, he has purchased a mobile phone insured with the opposite party number 2. Since he lost the mobile, the claim has not been repudiated by opposite party number 2. Repudiated by opposite party number 2. However, at the same time, the present petitions have been implemented as accused number 3 and 4. I have perused the complaint and the initial statement recorded under section 202 of CRPC. There is not an iota of allegation against either of the accused persons, either of the petitioners. Therefore, the complaint case which has been filed against the petitioner is misconceived insofar as the present petitions are concerned. Issue notice to the opposite party, returnable within so and so, and the meantime, proceeding qua the present petitioner, proceeding in ICC case number so and so,
88 of 2008.
qua the present petitioners are state. Yes.
28.
Yes. May I please, Your Lordship? Notice has already been given, my lord. But due to delay of 3 days, notice could not be issued, my lord. The notice may kindly be issued and take it some other day.
The requisite is filed.
Yes, my lord. Only 3 days delay, my lord. Due to
The
some...
requisite interim order is not there, no?
No.
The persons to the order dated 2/8/2000, the petitioner has filed requisite belatedly. Therefore, notice could not be issued. Utilize the requisites and issue press notice. Yes.
29.
Obligation.
May I please, Your Lordship? In a excise case, the excise official has seized a vehicle on 18th June 2021. This is the 4th monsoon. The vehicle is lying under open sky. And the interesting feature is that the owner is not an accused in the case. In additional documents, I have filed a citation of this Honorable Court, Ghosana Mahapatra versus State.
Proceeding is going on. This order is 23/12/2021. So, what is the status of that confiscation proceeding?
What is the
confiscation proceeding has not been disposed yet. It is still pending, and it was not initiated in the year 2021. It was initiated
where is the particulars of confiscation?
Kindly say that page.
It is still pending. It is still pending. Confiscation proceeding number is 48/22.
Case record as well the materials available therein. On perusal of the case record, it is seen that the alleged vehicle bearing number so and so and the chassis of so and so has been seized for commission of offence under section 8. Further, the IO has submitted that in its report before the court that confiscation proceeding of the said seized vehicle has already been. Well, he has to give instruction.
That order do not carry the confiscation case number. That order do not carry the confiscation case number, which indicates that no confiscation proceeding.
He says it's
Sir,
that has been pending.
He's saying that it is.
Sir,
that has been pending.
He's saying that it is disposed of.
No,
no.
Confiscation proceeding is
might be. I am not sure.
So he has to give instruction.
Oh, you have to tell me what is the status of
it is pending. Probably it is pending.
No, not probably, sir. You have to tell me definitely.
It is pending. It is still pending. It has not been.
No, you are.
There is none to take care of the. There is none to take care of those cases.
Not everything. You are not sure about.
No, I am
just urgent. Please get the definite instruction.
Sir, as per the observation of this Honorable Court,
and particulars of the confiscation proceeding as well, because there is no particular. It only says confiscation proceeding.
Confiscation going on. For that
particulars, the number, anything.
Here, the observation of this Honorable Court is that if the confiscation proceeding is not initiated within a reasonable period of 1 month, and cannot be disposed within a period of 3 months, then
I know you are right, absolutely correct. I'm with
I
you,
am
but,
not the accused. I am the owner of the vehicle.
I absolutely agree with you. We
Correct.
need to know what is the status of the confiscation. Please give me the number of confiscation proceeding
48 by
and the exact
2022.
status.
48 by
Exact status.
2022.
Then counsel for the petitioner shall furnish the exact particulars of the confiscation proceeding alleged to have been initiated against the petitioner for the confiscation of the vehicle in subject and the status of the confiscation. Lease the matter after a week. Yes.
In the next week, it will be.
There is also a division bench judgment that the IO should take steps to release all the vehicles. That is division bench judgment is there, madam, in such cases, madam, where, but he has no information whether the confiscation will be going on.
Once you know the status of that, maybe confiscation proceeding might have concluded also.
No, there is none to take care of these cases.
23, he has filed the CRLMC after 2 years.
Let him get the particulars. We'll see. Yes.
May I please? Proceeding for challenging the criminal proceeding, my lord. Questioning of criminal proceeding for commission of offence under section 376.
Give me. No, he has. Everything you keep it in your pocket.
No, my lord.
Reluctant to give it to the court.
458456.
What is the order?
Only
First or second order?
No, my lord. Only surrender. And
I can see that order.
Then surrender. You are asking for quashing. You got some order.
faster.
Surrender.
Can you see the order?
First or second. So this is the same petition. Or you have approached that court.
Yes, ma'am.
438 you have filed.
Yes.
Everything is given here. What do you want?
Only
the petitioner surrender before the court in the session for the aforesaid case and moves bail application. The same shall be considered on the merit and disposed of early in accordance with the law, so as to enable the petitioner to approach the next higher forum earlyly, in case necessary arise. Every word has to be injected inside for him to come to the court. This order takes care of everything.
And if he wants to surrender, he may modify.
You can't design an order according to your own choice. And if it doesn't come, then you keep on approaching the court. What this particular word has to be inserted. What is this? You went to 438 court. 438 court say that you surrender and your bail application will be decided by the first court as well as the second court in the same day. I'll further clarify and say. Petitioner has challenged the quashing order.
That is the proceeding.
Petitioner has filed the present petition seeking for the entire criminal prosecution initiated against him. Before that, he had filed a petition under section 438 CRPC seeking anticipatory bail. This court, by order dated 30th 7 2021 in ABPL number 8456 2019 passed the following order, para 4, following order. The petitioner at the outset submits that he is not the present petition. However, seeks indulgence of the court to the extent that he would be appearing before the court, his bail application shall be considered on the same day. It appears from the proceeding initiated by the petitioner under 438 NIS that the court had directed the petitioner to surrender and move bail application. However, he has not surrendered yet and seeks further time. Further time up till 31st of August 2024. In view thereof, the petition is directed to appear before the court on or before 31st August 2022 and avail remedy under law. If he moves application for grant of bail, the same shall be considered on the same day. Yes.
My lord, only
Yes.
thing, my lord, that 438, your lordship call that 438 NI Act, that should be CRPC.
438 NI.
No, no, your
CRPC.
lordship, no, no, your lordship, perhaps giving detection 438 NI Act.
No, for CRPC. NI Act. 138 sometime. 438 CRPC. Yeah.
One.
Please, your lordship.
Yes, madam.
Madam, this is an application for passing of the FIR and the charge sheet also has been submitted. The OP number 2 and the petitioner are both are friends and they are still friends and they want to compromise the matter also.
Compromise?
And the- and
354 only.
Yes, madam. So maybe notice so that she can file an affidavit.
My lord, this matter, yesterday this matter was there, though he has not removed the defect. So we the
Yeah,
affidavits. There are so many
Remove.
defects. And in
354 there, see the
354,
boy
5%.
must 33. The girl, what is the age for the victim?
21 at the time of the
They are
Petitioner
friends.
is 33, man. And OP number 2 is 21.
20?
21. Petitioner is 33.
They are friends, she says. It's only 354.
354, mind 354B, 341, 50. Charge sheet already submitted. He may raise this question before the 32.
No, they
32
settle.
my lord, the co-accused, my lord.
Huh?
32 was a co-accused, my lord. If they bring the this for the
Then she says that they have settled the dispute.
my lord, notice may be issued, my lord.
I'm just for the petitioner submits that
OP2.
they have settled the dispute. He has settled the dispute with the victim in the present case. In view thereof, issue notice to opposite party number 2, written within to
Both the cases, my lord. 31, 32.
34 and
31, 32.
31, 32. Serve and bring her.
Yes.
On VC also you can bring her so that we will quash it.
Yes.
354 only. Yes.
33.
This is a petition I have filed with the permission for preparation of a paper goods. Cost of the petitioner and early hearing of the criminal appeal because the petitioner is an old and disabled person, aged about 82 years of old. And says,
I am ready to hear, but forget about the paper book business.
I am ready to prepare. It may cost my lord.
No, cost is not more important. We have everything here. Get a pen drive and take it. Get a pen drive, take it, get the printout done if you want. And we'll hear, and rather you make 3 printout, give 1 to them, give 1 to the court. And forget about that. And get ready. Include karo isko, weekly. The matter is ready for final disposal. Learned counsel for the petitioner seeks time to appellant seeks time to prepare the paper book by obtaining the soft copy from the court record and leave the matter in the weekly. Get ready.
Fixing a date, my lord. Fixing a date, my lord.
Get ready. It will be included at the top. Get ready and give the copy to them and prepare a written note and come argue. No problem. Prepare a note also. Written submission. Make 3 copies. 1 give it to the court. 1 give it to the other side and get ready.
Right.
34.
May please go. Yes, sir.
34, madam. We have Mr. Maharana, my lord, vigilance case, madam.
Oh, Mr. Maharana is.
My difficulty is that my interim application is I have been given relief that if I file a petition for time, it will be considered liberally. And these cases are posted to
the same arrangement because he has a personal difficulty.
May I have a stay or because I am.
I will not stay. The same arrangement will continue.
Till further order.
Because in his absence, how can I do?
Till further order.
The same since Mr. Maharana is has some personal difficulty. He has sought an adjournment in this matter through Mr. Das, through Mr. Sangram Das, adjourned to so. The interim arrangement made in the earlier.
Initial order was 28/11/2023.
20th?
11/2023. Thereafter it was taken up. The
No,
first order.
17/8/23. Shall continue. Yes.
Okay.
35.
So I'm appearing for the informant in this case. 35 minutes appearing for the
Yes.
informant. My lord may notice that there is a certificate. The certificate says that there was a petition filed number 2332 of CRLMC number 2332 of 2021 that was dismissed for default on 17/5/23. Now this is a successive application without restoration of the one. So my lord, let the petitioner prove what are the changed circumstances under which the successive application has been
No,
filed.
this is criminal.
Madam, dismissed
You
for
are seeking what? You are seeking
Quashing, my lord.
Your lordship may kindly see
earlier.
earlier same prayer, but it was dismissed for non-prosecution. So that doesn't bar the second
Now,
application.
provided my lord, circumstances have not changed. If circumstances have-
Circumstances in bail application. No.
And my lord,
See,
it-
ideally speaking, dismiss in default, he should have
Restore this.
restoration, there is no provision in the CRPC.
My lord, the successive application, my lord, at any given point of time can be filed, my lord, depending on
Your lordship
their
may-
convenience.
your lordship
How is
may-
it maintained?
Actually, on merit, do you have a case?
Two-
Why have you got dismissed in default? For is a ploy for
No, no.
avoiding something or?
No, my lord, before the then Honorable Chief Justice, N block cases were being listed and.
Whatever it is, my lord, that cannot be a reason
No,
for
because
not
because his lordship asked, I am just explaining. Your lordship may kindly see the order
But
dated.
you can restore that. I am restoring immediately. And same day, same thing.
My lord, now at this stage,
The same thing. Even if you file a restoration, I'll restore it.
your lordship may kindly see
Better
the
that here it is.
2nd February 2024 order, your lordship may kindly.
Yes. Already passed, huh?
Yes.
Allegation in the FIR indicates that
Your
it is a
lordship,
pure and simple.
it was extensively hard on the first hearing
Has
itself,
already this-
and your lordship formed this
remedy
opinion.
provided is below, and the allegation in the FIR indicates that the injunction order passed in front from of the complaint is remember. Another FIR. What is this?
My lord, what I see.
2017 one FIR reached, and injunction order was passed, and that allegation is particularly violation of injunction order. So therefore another complaint.
No, my lord. My lord, what has happened, the fact, I filed a detailed objection, my lord will answer in time, but by that time, before that, what has happened in this case is.
See, I generally don't pass interim order
Yes.
unless there is a strong case.
My lord,
it is a strong case.
I was not there.
It was extensively
What
hard
was-
on the first hearing.
What was,
and I convinced
what was
your.
put before my lord?
Are you going to file?
I'll file a detailed objection.
For the opposite party seeks to file objection to the present petition, leaves the matter after 2 weeks, interim order to continue. File it. But you have a very difficult case.
No, my lord, I'll prove.
But civil suits are pending.
Why don't you settle it?
My lord,
is there any chance of settlement? I'll send it to mediation.
Both the parties want to up to Supreme Court, my lord.
And parties from Delhi intercede dispute between two erstwhile partners of a chartered accountant.
The land is mine. It is
Vishwas Tripathi.
Chartered accountancy firm.
But the charge sheet and the materials clearly show a cognizable offense. Electricity has been stolen. My lord, no, a charge sheet
You
has been
people are practicing chartered accountant.
Yes.
Both of you.
Yes.
Why are you litigating?
He was my.
They are having coffee farm at
He was my erstwhile partner who tendered a resignation because this project sustained loss. When it started profiting, then he came back and that is there on record itself in 2017.
So then there is a fair chance of settlement.
It
Shall I
has
send it to mediation?
No.
Why?
No, not at this stage, my lord. I'll tell why, my lords, I am saying so.
Arm
is-
twisting.
No, my lord. Why, my lords, I am saying it is pending for a long time now. If the matter was to be settled, it would have been settled. There are 2 civil suits pending, but that is besides the point. My point is, and I asked this question to myself. There is a land dispute. I am in my land. Admittedly, if somebody enters my land, beats me up, steals electricity, there will not be a criminal case, my lords. Even if there is a land dispute. That is the case that is now there before my lords. And that is clearly made out in the charge sheet. The 161 statements of the linemen. They have paid fines also to the department for illegally taking electricity from my land. They've entered my
Who
land,
has
beaten me up,
who has paid
threatening
fine?
me.
I am not. Other co-accused persons. I have come for Vishwas
The
Tirupati.
chief is the person, the
No,
petitioner.
no material of investigation. Paying,
I'll file my
paying
objection.
something
But
from.
still, I think you can settle.
I'll take instructions in the meantime when I file my objection.
You seek instruction,
My lord.
and I can refer it to mediation cell here.
I'll seek
See,
instructions.
you people are educated, chartered accountant and all.
I'm
Why
read
should
out
you-
for one sentence, madam. The further statement, Mr. Kamalachan Das, along with Mr. Vishwas Tripathi, has been restrained to enter his farm of the,
Yes, by the civil court.
Farm, as per the order of Honorable ADJ,
Yes.
Court Koraput. The same decision has been held by the Honorable High Court of Cuttack, Honorable Supreme Court of India. Now the above restraint, in spite of a restriction order, my lord.
That is
they have
exactly
returned
my case.
and taken the electricity from the
39(1)(2) injunction.
39(2)(a) is the
39(2)(a)
is the recourse.
recourse. Not the complaint. Anyway,
It's made out. I'll file my objection.
36.
Yes. I discussion for passing the cognizance because there is checkered history. My lord had detail on that day. My lord, page 64. Annexus 7.
who is appearing for?
Yes, he has appeared.
I am for the opposite party number 2 informant.
What are the allegations?
My lord, allegation is I am saying that
You are challenging the entire criminal prosecution.
passing of the cognizance.
Passing of a cognizance.
Cognizance dated for 13/4/2023.
Okay.
My lord, the cause of action which raised to this dispute, present dispute, realized in the 2020. That is page 64.
Page 24 को पढ़ाइले lordship पाइबे
Koi dos ko. Gote question. Page 60, my lord.
Yes.
Page 64 is my petition before the endowment commissioner that your land where the encroachers, including that.
No, that is not the test. You show me the complaint. Show me the initial statement. If any case is made out, made out. If
Yes,
it-
my lord, I am a little bit, my lord. That is the petition for which the police, the endowment commissioner took up the case. Thereafter, the endowment commissioner found that, yes, they have encroached the deity land. My lord's direction was that you verify whether they have encroached the land. And my lord, surprising fact that they have sold the land, the deity's land, they have sold by executing the separate page 60, no, page 61. Man.
61. Yes.
They have sold. The land belonging to date has been sold by way of a private notarized sale deed. So this advocate.
Without section 19.
Yes, my lord. Yes, my lord. Without, only on the basis of the notarized agreement, they have sold, they have misappropriated the government money. The deity is on the hunger, but they are selling the lands there. The cause of action raised that, my lord,
Then that is your grievance.
My lord.
You initiated this case against.
I initiated before the Honorable High Court also, page 66, my lord.
66.
Yes.
And therefore you say that since you have initiated, they are out of
They
ignorance,
have
filed.
outraged, out of rage, anger. My lord, the order was passed on 13/9/21 that you verify whether the land has been encroached. Thereafter, page 69. The endowment commissioner found that it is true.
Okay.
My lord, on 13/9, after the judgment was passed, my lord, they filed FIR on 29/9/21 against me that you have collected 30,000 each from 30 persons, amounting rupees 10,50,000, and you have not refunded.
That means both of you are eyeing over the deity's land. He successfully
I am not
got it, you didn't get.
I am not over the date. My lord, I am not over the date land. I am separate person. Because the dispute arises that I contested from Congress party. I am the general secretary of the Congress party. And they are the BJD.
Am I required to go into all these things at the
My lord, that is the cause of action. I am not interfering, my lords. I am not requesting the interference of my lords in that aspect. But the cause of action which raised to that.
I understand. This is maybe the
My lord, page.
out of vengeance he might
Yes,
have filed it.
my lord,
But
page.
whether he has made out a case or not, that's the question.
Page 13.
13.
Yes, my lord.
1-3.
Yes.
Yes.
Thereafter, they filed an FIR against me. Page 13 is the FIR.
And which has been
My lord, it has been
investigated and closure report filed.
It has been closed.
And there are no protest petitions.
Thereafter, they filed the 1CC case, which has
Petition, just show me protest petition, what are the allegation?
Yes,
and the statement under 202.
Yes, ma'am.
What are the initials?
That 25 page.
Page 35.
25. Come
Page
to
25 is the petition.
How many accused are there?
My lord, accused one.
Who are they then? Acha, witness.
They are the witnesses.
Out of
My
how
lord,
many witnesses? How many witnesses you have?
My lord, just my lord, assisting lordship, my lord. Here, my lord, page 25 lordship, annex 260 lordship file, the petition informant, my lord, the vendors, my lord, the Pariva Dokani vendors, my lord. The present petition is a doctorate, my lord. And doctorate, not doctor, doctorate, my lord. Will my lord,
Advocate, doctor, no? Advocate.
Doctor lecture pani
Doctor, someone doctor.
my lord. And he has, my lord, the president of the association. A Pariva market, jo ame garibo lokonko parimat, he is the president, my lord. They have, he has collected that 35,000 from each 35 members.
Who are you?
I am the from us. They have taken one.
You are one.
I am the informant. Informant in this case, my lord. Informant
You
along
are
with
one of the 4 men.
my lord.
Yes.
And who has encroached the
that is my senior, my friend, diverting the issue, my lord, from that side.
But whether that the petition was filed against you or not?
What, my lord?
That earlier the petition which he has filed, it was against you.
Now, that is case, my lord, I don't, my lord. So far, this affair concerned, my lord, they have.
Court, this court's proceeding is enclosed here.
My lord,
Whether you are party to that.
That I am party, you are
Yes.
party. My lord, I have not idea, my lord, so far the endowment case is concerned, my lord. Whether the
So
dating.
you are so poor man and encroaching the.
No, my lord, that is no, my lord, sir. My lord, I am submit, my lord.
But answer that. Answer proceeding of this court.
So far, my
Proceeding
lord,
of this court, there is a direction that you will not encroach and verification should be done.
that endowment department that can say, my lord, lordship, may direct issue notice to the endowment department whether we have encouraged or not. This is his allegation, my lord.
There he was, you were a party on.
When, my lord, this proceeding was started against him, he, my lord, through that this we are encouraging, my lord.
No, I am only examining one thing, that whether this is a arm twisting method of filing case, eyeing over the deity property or not. That's the only.
Your lord, endowment commission, your lordship, madam,
And
endowment.
what about 61? Who are you?
61, my lord, sir.
Page 60.
Just my appraising lordship, my lord, page number 25.
No,
the
you answer it. 61
60,
is the sale.
61 page, my lord.
Yes.
61 page, my lord.
You sold it for 7 lakhs.
Pitambara Behera. And my lord, I don't
What
know,
is
my
your
lord,
name?
who are the Pitambara, my lord, I don't know, my lord. I am the present case, I am the informant in the
Name. Your name.
Debraj Nahak.
I am not telling his name also.
My name is, my lord, informant Debraj. My lord.
My lord. The second witness is you who has the 30, the allegation is that I have taken 30,000 from 35 shops. The witness is Krishna Chandra Gowda, one of the vendor. My lord, he has sold, the Krishna Chandra Gowda has sold the land.
Yes. Yes, tell me.
No, my lord, my name is, my lord, that Debraj Nahak, my lord. The present informant in this case, my lord.
All these things are your defense, sir. Very direct. This he is not directly. His name is not there.
He is involved, my lord.
Show me that directly.
Yes,
I thought he is Pitambara.
The FIR is.
His name is something else. Name is
She apuni कहते हैं
Devraj Nahak. Show me Devraj Nahak is involved in
Yes,
the endowment thing.
his anticipatory bail, my lord, also High Court
1
rejected.
minute.
The Honorable High Court rejected anticipatory bail.
Then I have taken the bail and I am.
You show me Devraj Nahak is somehow related to that endowment case.
Yes, yes, my lord, my lord. Just a minute. Can I get 2 days time?
No, you show me.
No, just a minute.
No.
But I have to.
No. You just.
My lord, I
try
have to.
you
I have to
try
collect that.
No.
My lord, I have to collect another document. My lord.
No. These are defenses. I have full defenses.
Take it.
I stopped here because I thought that they are trying to encroach the deity's property.
Yeah.
You are not able to show. These disputes are something else.
ना माय लॉर्ड मते टिके गोटे मिनिट दियंत समय देखि दउछ
I am giving you full time. You tell me.
देखि दउछ
From these document which you have filed, show me where is Devaras.
ठीक है
It is Antaryami, it is Pitambara, it is Krishna Chandra.
ठीक है समय देका मुदा सेटा माइंड रे रखि नथिले
Please come to page 69.
हम
Page 61.
61 माय लॉर्ड
69.
69 page. You are
Last para. Deputy Commissioner of Endowment.
yes
read 9. Deputy Commissioner Endowment Commission's report.
my lord
Besides,
Yes,
a
yes.
further allegation.
my lord I am reading that
Petitioner Mr. Panigrahi, with regard to the encroachment of land of the DT and execution of a unregistered sale deed among the Pitambar Behra, Antaryami Panda, and Kushya Chandra Gowda in respect of so and so DT.
yes
Where is he? Where is he?
specifically
That's
Same as
unnecessary. You gave an impression. I thought he is Pitambara, so therefore I am attacking him.
my lord not that that's Deborah and
I don't know.
my lord
Petitioner. No.
my lord I may kindly giving only 2 days time
Please don't try to mislead.
my lord no
Can't
misleading.
mislead me.
My lord, no misleading. No,
You have misled me.
No, my lord. My fairly submitting it is not a misleading. My lord, 2 days time. I can get
You
that.
show me right now why today.
My lord, that is only aspect. My lord, I said
You said that he has encroached the government.
He has not.
DT's property.
The 35 vendors.
And you went to the court. This court.
Yes.
Court has passed some order.
My lord.
Thereafter the FIR was registered.
Yes.
You show me this gentleman was there.
My lord,
at proceeding.
Mate 2 days time. My lord, 2 days.
I unnecessary.
No, my lord.
And I tell you from the complaint and from the initial statement, 6 witnesses have told against you. 6 witnesses.
Yes, all.
Then why should I interfere?
No, my lord, I am paying for 2 days time.
No, these are defenses. I will give you the full liberty to raise your defenses. You may be having a genuine defense, but insofar as cognizance order is concerned, this court will not interfere.
Yes,
my lord, only the as regards Deborah Naik, I can
Even then, indirectly, you will get some document. Absolutely, you said will get some document. But those can be proved in the trial only.
Yes.
So, can that be a ground for quashing a cognizance order?
My lord, I am coming to this aspect. One aspect. My lord, 2 days time, my lord.
Sir, I am giving you full liberty. I am giving you full liberty. Raise all these points.
My lord.
Petitioner.
I said so that the clear evidence of the Deborah Naik.
I am really averse to the thing that if somebody misleads me.
My lord, I am not submitting. My lord, I beg apology. I have not misled, my lord.
Tuesday is the first item.
Yes, my lord.
Tuesday is the first item. Because of you are requesting. Because of you.
No, I said prove clearly.
Don't make this kind of.
Yeah, no, my lord. No, my lord. I am not misleading, my lord.
Tuesday first item. Huh?
Yes, my lord.
If you want to file anything, you file it.
Yes.
If there is any direct thing.
Yes, my lord.
Right.
Let's say item 37, quashing of a cognizance is pending before the Hon'Ble Supreme Court. Let's say kindly taken up after 2 weeks.
No.
Cognizance order?
Supreme Court pending is.
Just a minute, I have filed IA.
This is the.
Your Lordship, may kindly first look at the IA. IA 1213 of 2024. 1213 of 24.
Yes.
My lord, with your permission, 20 तारीख my lord, lordship. 20 तारीख my lord, 21 तारीख. First item 21 तारीख.
Your Lordship, may kindly look at IA 1213 of 24.
Yes, I am there.
My lord.
Yes, prayer.
One set of accused had come here. The cognizance was confirmed. And thereafter, another set of accused, they have come. They say that we have gone to Supreme Court. Supreme Court has not passed any interim order. Not passed any interim.
Only issue notice.
Yes. And your Lordship has granted stay. My prayer is for vacating that stay order.
I have stayed.
Yes.
So,
Your Lordship, will kindly see page 2 of my IA. I have quoted order dated 9/4/24.
Let's say yesterday
that one of the co-accused persons and who is the husband has approached the court by filing so and so. The coordinator of this court by order has been pleased to dismiss the nomination. Against the said order, SLP is filed. Therefore, this court adjourned the matter to so awaiting the outcome of SLP. That is why I stayed.
My lord.
I said in that order that one of the
Only a-
husband has approved this court.
No, yes, yes.
And
Two-
the
one set of
petition was dismissed.
Ma'am.
Therefore, he is gone to Supreme Court.
No, he did not go. One set of accused came before this honorable court. This honorable court upheld the cognizance, order of cognizance.
Against that, they filed a set.
Another set of co-accused, they have gone to Supreme Court. I have given the order of this honorable court.
Let's say, I am yesterday is pending.
Another Akshay Kumar Naik.
Yes, I have given that order. Copy of the order.
Serial number 2329 by.
Yes, yes.
2020.
There are more higher.
2329.
Page 6, minor, on it.
Let's say kindly taken over up to 2 weeks. Let's say.
You tell me one thing. What will be the if the Supreme Court allows it? Not the
Supreme
contingent,
Court in its wisdom has not passed an interim order.
but it can quash also.
If it is quashed, then it will take its own effect. It will have its own effect. But Supreme Court naturally.
Once it is brought to the notice of the High Court.
Yes.
That there is a petition pending in Supreme Court.
Petition pending.
Is it not that propriety demands that I should wait?
But
for
Supreme
the
Court
outcome?
itself has not thought it in its own
Stay is
wisdom.
something different. Stay is something.
It has not passed an interim order.
Stay is something different.
That is right, but when Supreme Court it's passed an interim order. If it allows that it would have its own effect.
Have you filed reply to the application?
I have already.
You have filed. Notice was issued in the issue notice in IA number 1213 2004. Issue notice to the petitioner. This IA is filed by the opposite party.
My lord, copy was served on as early as on 6/5/24.
Issue notice to the petitioner and the.
No, he is appearing. So
I am.
Despite the fact that a copy of the said IA has been supplied to the petitioner, petitioner has not responded to the said application. On behalf of the petitioner, further adjournment is sought in the matter.
Let's say interim order
on the
continue.
ground, on the ground. Let me complete. On the ground that the SLP is still pending, it's not disposed of. However, in the contrary, the opposite party number 2 is seeking variation of interim order on the ground that the Honorable Supreme Court has also not stayed the trial court proceeding. In that view of matter, please, in that view of the matter, the hearing of the application is deserves merit and least it on circumstances. It is made clear that no further adjournment shall be given on the ground that on the ground of a pendency of the proceeding before the Honorable Supreme Court.
Let's say interim order continue.
Interim order to continue. Yes.
It will
You
be
get it, mention it and get it listed.
It will be listed.
He'll give a date. Yes.
Let's say.
Please, Your Lordship. My lord, the petitioners have prayed for quashing of the proceeding which has been filed by the present OP number 2, my lord, under section 12 of the Protection of Women from Domestic Violence Act 2005. OP 2, he has appeared, my lord, through my learned friend.
Serve with a copy.
I have given the copy. This is the receipt, my lord. Last occasion I gave the copy. He received the copy. This is the copy, my lord. He has received. As per my lord's order.
He doesn't have anything.
Copy, my lord, I can give, but it.
This is there also. I kindly serve. Really sorry.
Land Counsel for the opposite party number 2 submits that he has not received the copy of the petition from the petitioner. He seeks one more time. A copy of the petition may be supplied to the opposite party number 2, list the matter. Yes.
Interim order to continue.
Interim order to continue.
Actually, it is a DB proceeding he has challenged.
I'll send it to mediation and
My lord, page 39, my lord.
My lord, your kindly.
39?
39.
No,
39.
No, 38. 38 hours hearing or 39?
This is 38, my lord.
Page 39.
Page 39.
My lord,
Okay.
page 39, second para, after my lord, 6th line.
Ah.
39.
Right.
Okay.
That the complainant,
Hmm.
the complainant wants to be with her husband and not to wish to take back the dowry articles. Hence, she denied to take the dowry. It's why it will be better if they will send to mediation. That
No, that is not the fact, my lord.
Why can't you go to mediation and do?
Lord, can you see, we are the in-laws. We are nowhere related, my lord. Sister-in-laws, my lord, and their
So
husbands.
in-law doesn't mean that you will not settle.
No, not that is not. With great respect, my lord. Two earlier criminal cases have been filed by the OP number 2 against her husband. In those cases, my lord, neither the in-laws have been named in the affair nor they are charge sheeted, meaning thereby no torture has been meted out to her by the in-laws. This case he has filed against.
No, on merit you may be having a case. What is wrong in giving a try for settlement? That's what he's saying.
Let's settle back.
Interim order, I'll continue. Go and try. If something happens, happens. If something will not happen, we'll hear you on merits. What is it? Material dispute, don't, precipitate the thing.
Entire case, my lord.
Again, you are going on merits.
No, my lord, I do not disagree for any mediation. But in earlier cases, my lord, other cases are there, my lord, divorce case is also there. Their mediation has been happening between husband and wife. So these in-laws have been unnecessarily embroiled. Therefore, my lord, I relied on the coordinate bench judgments, my lord, that in-laws should not be prosecuted without any rhyme and reason. It is the husband. The court and thrust of the allegation is against the husband by the OP number 2. So let the proceeding continue with the husband, my lord. And this petition number.
You will be happy that your son should face the trial. Be out.
No. That is not my.
That's what you are saying.
True.
Let my son face it. I'll not settle it.
Lord, for this case also let there be mediation, my lord.
Let there be mediation. The entire proceeding against your son and everything can be settled. What is wrong in it? Give a try. Give a try. Right on. The petition, the present petition dispute is arising out of a matrimonial discord. After pursuant to the pursuant to the notice, Mr. So-and-so appeared for opposite party number 2. Perusal of the reveals that the dispute is essentially due to misunderstanding in the matrimonial of the opposite party number 2. I think it is expedient to relegate the parties to the mediation. Accordingly, the parties are directed to appear before the mediation High Court Mediation Center on a date to be fixed by the coordinator and intimated to the parties. After the settlement, the mediator before the mediation center, the matter could be heard. Accordingly, awaiting the mediation report, release the matter on certain Saturday after 3 weeks ago, interim order to continue. And go with open mind and try to do it. If it doesn't happen, then on merit we'll see. And I'll quash. See, if you are so adamant you want to prosecute the entire family, why should the old parent-in-law will suffer because of the fight between you and your husband? You keep on fighting with your husband. I will quash it. Send the message to your client. If you are so happy to fight it out with your husband, because they are old parents. Why should unnecessary they will suffer?
If it fails, I'll submit that.
Otherwise, I'll quash it. If you don't settle, I'll quash it. I will not hear him a single second also. I'll just quash it.
Okay.
Yes.
39.
Mr. Das.
There, I am exhausting the board completely.
Mr. Das.
39 yesterday this matter was there. Only he has to take instruction how much amount he was in custody.
Oh, the same matter. What is this? This is going on and on. Revision? Revision, huh? I've heard already.
That point he has to take verify the record.
But I don't think he will do it. This has been pending. You please help. You please help. Let him do. Let him help. ଆପଣ ଟିକେ ଦେଖି ଦିଅନ୍ତୁ ଯଦି କରିପାରିବେ।
ନେକ୍ସଟ
Let it be. Thank you for your. This small thing, matter was heard and unnecessary is pending. Yes.
41.
Just check it up if that is there. Yes.
41.
No, 42. 41.
This particular revision, my lords, that against an orders rejecting his 457 application, my lords. All the London trial courts released all the savings banks account and all this thing. Now the grievance is paid with the fixed deposit, 25 fixed deposit short to be released.
Adjourn after 3 weeks. Non-APS for the petitioner. We'll see.
And if a lordship permits, my lords, I'm going through the different recent judgments, my lords. Now, my lords, an application filed under section 457, my lords. And a number of cases are coming up, my lord, with a lot of expectations, my lords. My lords, even they are not content because when I make submission that we're ready to release on subject to deposit of bank securities. Now they want more and more relief, and the cases are filling up. What I suggest, my lord, in this case, my lord, this Honorable Supreme Court has passed the orders with regard to application. What I say, my lord, this particular revision is barred under section 397(7). You can turn to the last portion.
You are talking about item number 42.
43 months.
41.
41, sorry. 41. I'm not placing any case, my lord. I'm only on.
I have adjourned, but I want to know what is this.
Let's turn to paragraph 5, my lords.
Secondly,
what was not realized was that the orders passed by the trial court refusing to call the documents and rejecting application under section 311. This pertains to 311 and 91 CRPC, where interlocutory orders as such, the revision against those orders are clearly barred under section 397(2) CRPC. In its common orders and clearly mentioned that the check was admittedly signed by the respondent accused, and the only defense that was raised was that his signed checks were lost and an appellant.
So you say that revisions are not maintained.
The reason they prescribed this order didn't in any manner decide anything finally. And my lords, I've got.
But these are the applications which come under 457.
Yes, no, yes, my lord. I've got a judgment of. Madhya Pradesh High Court also, my lords, and their Honorable Supreme Court, they dealt with the application and the
revision doesn't lie.
If they ascribe the reasons, my lords, if the order is passed only to give possession of property during pendency of the trial, now the fixed deposits are properties, my lord. If the order is passed only to give possession of property during pendency of the trial, such order will not be an interlocutory orders and criminal revision shall not be maintained. Will be an interlocutory order and criminal revision shall not be maintained due to bar created under section 397(2) of the Criminal Procedure Code. So because the possession of the property for interim periods, particularly during pendency.
Suppose it is rejected, 457 is rejected, then it is a final order. Where appeal doesn't appeal.
Right, but that ultimately the release is not disposed of. The test is by allowing the revision.
No, in many cases they file revision after the rejection of 457 application. Once it is rejected, it is a final order. If it is allowed, it is an interim order.
If it is rejected,
it is a final order. Since appeal is not provided, revision lies.
Then, my lords, that in thereby allowing the revision in a case where
once it is allowed, it is for an interregnum period till it is a contingent upon the trial. So therefore, it is an interim order. But once it is rejected, the finality is attached to that application. So therefore, revision lies.
But the lease is not disposed of. For example, in 311. And 91.
Suppose there is a conditional, if there is a conditional release or something of that sort, in that case, revision.
Anyway, I'll come back to your lordship with the application of my.
So that is the catch.
That's right.
That is the catch. Yes.
I think this is the last case.
Last case. Okay. 42. Nobody appears.
My lord.
Yes.
My lord.
Not required.
Shortly going. Petition challenge the order of a conviction of both courts. And Metro is now compromised under court last date, had the matter and directed decision in this regard. How can?
Offense?
Offense, my lord, 436. Informant says the deposition more 10,000 loss is only.
What judgment?
My lord, that the direct decision. In the Metro is compromised between the parties.
Which offense? Which offense?
436 is the case.
436.
My lord.
What does it say? 436, yes.
My lord.
And compromise, and they acquitted you.
Acquitted.
Particularly in view of the particular offense and the parties have compromised the matter and this court by exercising power. No. There was no conviction.
May I please?
It was 482 petition was filed.
No, 482, my lord.
That's what the last.
Also acquitted. Conviction set aside.
Consequently, in view of the peculiar facts and circumstances of the case, wherein the parties have compromised the matter at hand, and this court, while exercising power vested under section 482 CRPC, deem it fit to accept the prayer and pass it. That's right, but I'm exercising revisional jurisdiction. Therefore, I say that get some judgment.
482 always available, my lord.
In the revision jurisdiction, I like exercise 482. Here in this case, what happened?
The decision was after conviction. Conviction set aside, madam. I'll read the decision.
Yes.
Conviction set aside.
Yes, what do you say? And it was challenged. Conviction order was challenged. However, the court says that I can exercise 482 and quash because they have settled the dispute. Offense is 436. Same offense here.
Same, direct power of decision.
Directly.
That is there, but that is exercising inherent power.
But this is directly judgment what to do. Direct judgment.
I get.
So in my case of a merit, my lord, I witness now.
Somehow I am convinced. Don't dissuade me to go against you. Hold it. You are covered by this judgment. I will not read anything. Record an acquittal. Record an acquittal.
Pardon, my lord, in item number 6. Pardon, my lord, in item number 6.
Yes.
Second bail application filed before charge sheet, my lord, but wrongly submitted after charge sheet. First bail application is also received with the grant liberty to file after charge sheet. Second bail application also same order.
Then why have you said like this?
Before charge sheet wrongly stated that after charge sheet filed. Thank you.
629
bail
629 সেটা কি সেম অর্ডার করে দাও উপরটা কিন্তু
My lord, I will just submission. I have got a submission, my lords.
Yes.
All my lord and colleagues, my lord, they join with me in my wishing my lord a safe journey. Actually, you can now.
That is every month.